Most of the cases that went on review was related to drug-related trials, and in line with Section 20 of the High Court Act, the 7 cases were taken on review by a 2-member judge panel. In the matter between the state versus Shimirimana Jadotia, the panel set aside the conviction and his 24-month jail sentence. The accused appeared before the Ocho Magistrates Court in February this year after he was found to be in possession of dependence-producing substances. The value was estimated at over $11,000, and the accused pleaded guilty and was sentenced to 24 months in jail. The review court, however, asked the magistrate to explain how the magistrate could reasonably ascertain that the accused person knew the substance was indeed cannabis, upon which the magistrate responded that the accused person could identify the plant by smell. In the review judgment, the Superior Court concluded that the law requires that the court be satisfied about the accused person's guilt before convicting him or her, saying there is a need for corroborative evidence such as an analyst's certificate or testimony from a police officer familiar with the substance. The State versus Luvialan Bierkes is another matter in which the judiciary exhibits self-correction. Bierkes too was charged with dealing in a dependence-producing substance, alternatively possession of a dependence-producing substance. He pleaded not guilty on the main count of dealing and guilty on the alternative count of possession, and was subsequently convicted on the charge of possession and sentenced to a fine of $6,000 or 2 years imprisonment. Upon the Superior Court asking the magistrate if he was satisfied that the accused knew that the substance he was caught with was cannabis, in light of the fact that there was no laboratory analysis presented, the magistrate said that the accused knew what the drugs were and as such, laboratory results were not needed. The magistrate was adamant that the accused admitted all the allegations in the charge and was rightfully convicted. However, the review panel found that the magistrate could not have been satisfied that the accused indeed knew it was cannabis. Accordingly, the conviction and sentence stand to be set aside. ML Sebeb, NBC News, Windhoek.